Us now.
Yes.
If you get a second, I know you're busy. But
Well,
you-
no.
We're going to go ahead
Have that discussion.
Okay.
start our lunch presentation. I wanted to start out by introducing the panel. I think it's interesting. We have a practitioner, Thor Hearne. We have a jurist, Virginia Norton from Florida, and a professor, Shelley Saxer from Pepperdine. So we're really kind of covering the spectrum of our conference. So just taking a couple of minutes first, we're going to talk about emerging issues from the different perspectives of a professor, the bench, and the practicing bar. But what I wanted to do was to go back and tell you where we were 8 years ago. Let's see if I can get it. We were in Beijing at Tsinghua University having our international conference, our first one. As some of you know, 2 years ago, we had our second international conference at The Hague. But 8 years ago, I don't think Linda's in the room, but Linda Butler will tell you, we chose to go to China because China was opening the door to property rights. And we were impressed, and we wanted to have a discussion with the academy there, which we did. And it was very interesting because the young professors spoke about opening the world through property rights. Some of the older professors, we could tell, took kind of the party line back then. But that's why we went to Beijing. And that was our conference, and it was a great conference. And people have asked me to this day, why did you go to China? Because China was opening the door to property rights. This was our conference, and it was really neat because we had these simultaneous translations, so as the professors spoke or the practitioners, you immediately heard what they were saying. And so about 3 years later, we started to see an erosion of the civil rights and property rights in China. Because, and I'm going to talk about this, those of us in the practicing bar, we don't see property rights as many sometimes people in the courtroom do, as all about money. Not at all. We see the connection, I say, between human dignity and our civil rights. So just 3 years after that, the Washington Post talked about the erosion of civil liberties and property rights in China. And then these are current articles. I'll step back here. In the last several months in the Washington Post, what's going on in Hong Kong, in Beijing, in China, and we're seeing a complete reversal of property rights, which directly affects the civil rights, and a reversal of civil rights, which they're able to do because there are no property rights that are truly respected. I don't know if Jim Ely's in the room, but Jim Ely's great book, there's Jim, on property rights and the guardian of every other right. We practitioners know how true that is. So here's some local examples of property rights. You'll see to the left, C&U recognizes, it's Christopher Newport University, a Virginia university just 20 miles down the road here, Newport News. This gentleman fought for their black community. Their community lost all of their land, their neighborhoods, for that university. So often, the practitioners will tell you that those that are most vulnerable are the minorities and the elderly and those that are not connected politically. Those are the people who most often give up their land in society. Let me go back. And so Black people's land was stolen was an article by a UVA professor this summer in the New York Times about how minorities have suffered adversely as property rights are taken from them. And then property seizures get new scrutiny. So constantly, property rights are at the forefront of our civil rights. And one of the things that we try to do here at Brigham-Kanner, right, Linda, is connect the dots to property rights and our civil rights and our civil liberties. So I'm real excited for this panel this afternoon. We're going to lead with a Florida trial judge, Virginia Norton. And Virginia, thank you for coming up here.
Thank you so much.
You can use that mic, I take it.
I'm just going to sit here. It's lunchtime, so I'm just going to sit here. First of all, I want to thank you for the invitation. It's an honor to be here. Whenever I speak at conferences, I think one of the earlier speakers said that there was the theorist group, or I'm part of the doer group. And the first thing I want to let you all know, I am not a fancy academic, and I'm a crusty old trial judge. What I do and what I love is to try cases. And my docket comprises in the 4th Judicial Circuit, which is composed of 3 counties in Northeast Florida. I do the majority of complex civil cases. So most of my civil trials last anywhere from 2 to 5 weeks. And it's what I love to do, it's to try cases. And when I come to conferences like this, I'll be quite candid with you, I really do not do a lot of preparation until I wait and hear what people are talking about. Because when you're the trial judge on the docket for that day, usually people have a lot of questions for you that they've wanted to ask judges about how to present their cases, and I'm always happy to answer the questions I can. I've presided over probably over 10 eminent domain cases, which is a great deal for a state trial court judge. I've seen it done very well, and I've also seen it done where there was a little room, or maybe I'll gently say a lot of room for improvement. And so I'm always happy to answer questions when I can answer the questions within the rules of the judicial ethics that bind me. The first thing that I did want to address that was brought up several times this morning, and I don't mean this in a negative way, but it's the elephant in the lecture room, shall we say, is the difference between state judges and federal judges. Obviously, we all know how U.S. District Court judges are selected. However, we also know each state has a different way of selecting its judges. The state of Florida, where I am from, you can be either elected or you can be appointed to the state court trial court bench. I'll be very candid with you. I was 34 years old, decided I wanted to be a judge, and I ran. So I am an elected judge, so I'm a little bit biased about that. But there are great judges who've been both elected and appointed in the state of Florida. But I always like to talk about this issue of hometowning, because everyone who's ever gone to law school knows why the federal court system was devised by our forefathers. And so there would not be that local sense of interest, the idea that there would be no local bias. And I know that a lot of practitioners fear when they go in front of a state court judge that there's going to be local bias. If the judge is up for re-election, that he or she might vote in a way to favor a group of people who may back his or her re-election campaign. There are so many law review articles on the selection of judges, the issue of who is the judiciary accountable to. We could have a whole separate conference on that issue alone. I can just speak from the bench that I come from. I know myself, I believe to do my job the right way, I have to be willing to lose my job. And I think a lot of my colleagues feel the same way. And I do think the state court bench that I sit on is one that's ruled by the law and not public opinion. But I always do like to address that because I know that's always a concern. And I'm not saying it's not a legitimate concern. I just know that the bench I serve on, I do not see that as a driving force. But since there is that concern of local influence, it gets to what I like to discuss a lot at these conferences in the selection of a jury panel, your voir dire. I have to tell you, selecting a panel for an eminent domain case is not for the faint of heart. Not for the faint of heart. I was telling Thor over here, most jurors, and I mean this in the best case scenario, they want a case with a gun, a whodunit. There's gonna maybe some DNA evidence, you know, it's like CSI. And when you tell them we're gonna have these great appraisers coming in and it's gonna be great, they kind of look at me like, and I always have really good snacks for the jurors at my eminent domain trial. So I want to let you know that if your judge is not doing that for your jury, you might want to say you'll each pay half to keep the snacks going. Because quite candidly, I think that first of all, jurors, when they get called to an eminent domain courtroom, first of all, they usually don't even know what it is. They don't know what the taking clause is. They're a little confused why they're there about a piece of property. And it's very overwhelming. I always tell people, when you're a lawyer, the best way to start off getting ready to pick your jury is to pretend you're going to the hospital. And by that I mean this. I know when I go to the hospital, it's very scary, it's very overwhelming, it's not where I'm used to being. That's how our panelists are when they walk into the courthouse. It's an overwhelming experience. There's lots of police officers, there's lawyers, there's pomp and circumstance. And because we go over there every day, we lose sight of that. So you've already got a group of people who are slightly overwhelmed. They're being put in lines, they're being sent to different places, and they're then sent to a courtroom. And what they've seen on television is basically criminal law, and you're about to explain a whole new area of the law that they're not even aware of. These are the suggestions that I always give to people in complex cases, but especially I'm going to focus right now on some suggestions in the field of eminent domain. Your job, first and foremost, before you even start to pick a panel, is to educate your panel. If they do not understand what the law is, if they do not understand what the facts of your case are, they're not going to be able to understand the questions. I've seen a lot of very, very smart lawyers come in and start asking questions of the panel, and they're asking it in a way where the average lay person does not understand what they are talking about. And so I would highly suggest to you, when especially if you've never, I know we have people of all different levels of experience in this room. If you haven't picked a jury in a long time, or if it's one of your first juries to pick, try explaining eminent domain to someone who knows nothing about it. And then when you get done explaining it to them, say, what did you think I just heard? Because it is a complex idea, and it's something the general public, if they've heard about it, it's been usually in some draconian way on the evening news. So your first goal when you go in to pick a jury is you have to educate the panel on what eminent domain is. Then number two, you have to educate the panel in a way that is interesting about what the facts of your case are. And then the third thing is that means you're going to have to humanize your client. Now, that's either if you're representing the taking authority or if you're representing the private landowner, because neither side is for the faint of heart. An emerging area in eminent domain trial, I have to tell you, I think panelists are confused why taxpayer dollars are being used for a case that's purely about money. And I think they are suspicious of private landowners who, in their mind, and always remember the demographic of your panel, what they are doing for a living. I've seen a lot of really good lawyers not take down and remember their panel, what they do for a living. Because I've seen really good lawyers get up there and explain monetary amounts in a very cavalier manner when that one piece of property is worth more than a specific panelist will make in his or her entire life. So you have to pay attention to the economic standing of your panel in the way that you explain damages specifically. Because the average panelist is not going to have a great deal of empathy about a private landowner. And remember, your average panelist may, if he or she is fortunate, own a home. So if you're there trying to describe an individual private landowner who has investment property specifically, you have to explain it in a way in which it's going to make a panelist care. Then in terms of if you represent the taking authority, you have to humanize an artificial individual. And I think that can be done in many ways by who you get to choose to represent the taking authority. Just because someone has a fancy title, a fancy degree, they went to a fancy college, does not mean a panelist is going to be impressed by that individual. You need to have an individual who can explain and who can connect. Remember, your goal as the lawyer in the trial is to explain to the panel in a way that they can understand. And let me add, jurors are also a whole lot smarter than a lot of people give them credit for, so they can come up to the right decision. I also would strongly encourage every person in this room, if you've not tried it, try a jury questionnaire. I know that they're commonly used in federal court. I'm a huge advocate. When I teach to the new civil judges in the state trial court system in Florida, I really, really advocate jury questionnaires. I think trial lawyers, they've gotten a bad name. I don't think that means that it takes away your ability to connect with the jury. I like to do a hybrid in my complex cases. There's a way, if you have questions later, I'll answer it how I run it fairly smoothly, I think. But that jury questionnaire can really, really help you get through that panel, and people will write down things that they might be embarrassed to say in front of a group of people. And don't think you have to use a jury questionnaire only for a large, complex trial. I've seen them used very effectively for 5-day trials. And I would strongly urge that specifically in an eminent domain case, and I'll tell you why. A lot of people are visual learners, and when they see it written down and they have to answer it in writing, I think they sometimes put more attention to it than if they're just answering in an open courtroom. So I wanted to add that because I've tried to get people to do this more in the eminent domain cases I handle, and people are very, very hesitant to do it. So I've used up my time, but that's what the crusty trial judge has to say. But during the question period, I like to talk about the use of questionnaires. If you want to talk about it afterwards today, I think people really, really, they've gotten a bad name, and I think they're a wonderful tool for a trial lawyer. So thank you.
Thanks, Virginia. And by the way, we're going to take our questions, the panel decided at the very end, so if you'll hold your questions, and when we finish the entire panel, then we'll take our questions. But thanks. So Thor.
Thank you, Joe. And let me just say, echo first the point you made at the beginning that property rights are civil rights. Justice Rehnquist famously said that the takings clause was treated as a poor relation relative to other civil rights, but I think that tide is turning with cases such as Nick, and I think the current court has much more understanding, maybe a fuller orbed understanding of the need for property rights, and Jim Ely's work that I highly commend Jim's work on that book, Guardian of All Rights. And then I want to just say thank you all, Linda and Andy and others here at William & Mary for this conference. I was there in China and been here since, and it is a truly remarkable endeavor. When you look around the room, you see the expertise that's present, you see the people who are on these panels, particularly the morning panel, I thought was very impressive. Professor Eagle, as Robert Thomas said, his work on regulatory takings literally is on my bookshelf right next to my desk, and there's probably not a week or two that goes by where I don't consult that. And so the scholarship that is represented by this effort is really, truly remarkable. And I just am honored to be part of the process. Shelley and I have worked together on some amicus briefs in the Supreme Court. Jim Ely has been one of the amici in a number of the cases, and others have. It has really been a wonderful forum to try to communicate both the law as a practitioner as well as an academic and within the judiciary. When you put those three together, as Joe, you said on this panel, what we are able to do is shape and inform the way property law is understood, the way it's practiced, and the way it is implemented by the judges when they interpret it. And I think most of the judges that I've spoken with have been appreciative of the effort, whether it's an amicus brief or whether it's good advocacy in the courtroom. That has allowed them to do a better job. And again, going back to the point that property rights really are civil rights. I wanted to just, our panel is tasked with emerging issues, and as a practitioner, I wanted to just address several that I know are, from my perspective, emerging in the area of the Fifth Amendment, takings clause, litigation, and jurisprudence. The first would be the question of state versus federal law. Now, and I'm not going to steal Andrew's, because you're going to give a much fuller.
No, I need your help.
So, but that is a issue, and I will just give you an introduction, and Andrew's going to do the layman's work here, or the yeoman's work on this one. It is a question of whether compensation is defined by federal or state law, particularly when the condemning authority is acting under a federal grant of eminent domain. So you have private pipeline companies that have been granted by the federal government the power of eminent domain. So the question which we presented to the 11th Circuit recently was, does Florida state law define just compensation, or does the federal jurisprudence define just compensation? That's a interesting point, because in Florida that compensation includes making the owner whole, which includes attorney's fees, litigation costs, really bringing the owner back to status quo. It's an important and consequential point. Again, Andrew's going to talk a little more about that, but I would say from my perspective as a practitioner, I go back to the point. Property rights are civil rights. If you do not have access to an attorney who can take the case and fund the case, and they are expensive and time-consuming, the individual does not get compensated. The individual does not have a right. A right without a remedy is no right at all. And that is one of the challenges that we face as practitioners, because we have to undertake the cost of representing individual property owners. And so the obligation of the federal government under a statute or a condemning authority under a state provision such as Florida to compensate and make the owner whole. There's a wonderful case. There's a whole host of early federal cases. One of my favorites is Monongahela, which is a Supreme Court case that had to do with the federal government condemning a lock and dam. In that, the federal government said, and they've echoed it in Miller and a number of other cases since then, they have said you must make the owner whole. Put him in the same pecuniary position he would have been had the government not taken his property. And that's particularly important when you have property that's taken not in an ordinary transaction. This is under compulsion. The government comes in, or a condemning authority under the government's eminent domain authority, and takes something from somebody, and that person then bears the expense of going through an inverse condemnation action, years of litigation, has to find an advocate for them who's willing or able to advocate that their right to compensation be paid, and that that the owner is brought back to a position of being whole. And that's the objective that I have, that Andrea and others who practice in this area, that's what we have. So we have a lot of the academic concerns that come into that. But at the bottom of the equation is the need to have effective advocacy, which requires that there be a mechanism to bring the owner whole and to compensate for the process of being made whole. And so that's an emerging issue that we're facing, and as I said, Andrew will talk more about that. Another issue, which I was with many other people, some in the room, we were working on is an amicus brief in a case called Brott versus United States. That issue is still coming around. I think Jim Burling's here. That issue is still going to come up in another case. The question is this, and I appreciated very much, Judge, your discussion of jury selection and how important that is. I practice mostly inverse condemnation in federal court. So when the federal government takes property, without coming up to the owner up front and offering any compensation, we have to bring an inverse condemnation action. The only court that hears those cases, you're restricted to the U.S. Court of Federal Claims, which is not an Article III court. It's an Article I court. The judges are only appointed for a 15-year term, and you do not get a jury. I envy getting juries. I've had a number of jury trials, and I always enjoy those and have great confidence in it. Now, the judges on the Court of Claims are some of the finest judges I've practiced in front of.
This is being videoed, so that's good you said that.
I'll mention names too, because some of them, Eric Burdick is a very good judge. Judge Williams is outstanding. So, but my point is, the issue with the Court of Claims is, I would tell those judges they should be Article III judges, and they should be able to try a case with the jury, because the advantage a jury brings to the process of deliberating compensation is, I think, very helpful. And I think they would appreciate it. And it would also be nice to get them life tenure. So the other emerging issues that I see are the difference between regulatory takings and per se takings. Now that sounds, I know, a little bit technical, but let me give you the context. A number of the cases I handle are called Trails Act cases. So the federal government created a law that said when a railroad easement expires, terminates, instead of the owner getting the property back unencumbered by any easement, they're going to impose a new federal easement for both public recreation and for potentially a future railroad. The Supreme Court in Prousseau versus United States, 494 U.S. 1, 1990, decided that that was held correctly, that that was a compensable taking under the Fifth Amendment, so that the federal government must compensate, and the way that the owner is compensated is to bring a claim in the Court of Claims. So the government's response recently, particularly the Justice Department, has been to try to realign that sense of jurisprudence and say that it's not really a taking, but rather it is a regulatory taking for which you look at Penn Central and ultimately no compensation. And so the example that they have right now is a case that is called Cacklen. In Cacklen, there were some, it's not my case, I've written an amicus in it, but it was some farmers up in Iowa had some property, and the government took it for one of these rail trail corridor easements. But then at the end, the government abandoned the taking, and the property was returned to the owners. Judge Leto said, okay, you have to pay them for the time you took their property, which was $800. So you would think, fine, just pay them their $800. Well, that's not what the federal government's done. Instead, they're using this case to try to argue that rail-to-trail takings, despite the Supreme Court, despite an en banc decision of the Federal Circuit, despite a decision of the Eighth Circuit and several other circuits, are going to say, no, this is just a regulatory taking for which no compensation is due. So what they're trying to argue is to overturn a lot of that precedent. They're asking right now for en banc rehearing of at least 3-4 of the Federal Circuit's prior decisions. But that is, again, I come back to the perspective. This is over a $800 liability of the federal government. They have already run up, just put aside their costs, the Justice Department's costs, the cost to the court. It has to be at least $2.5–3 million. They've gone up to the Federal Circuit once, lost. They're trying to go up again. That's what, as a practitioner, the owners confront. And if you're a property owner, you can't mount that challenge to vindicate that right unless you have practitioners and a system that allows us to bring these cases. I could represent very wealthy people all day long who can pay the costs of litigation. The person, as Joe was saying, the people who are most victim of that, government condemnation, government taking their property without compensation, who are in the greatest challenge to vindicate their right are the poor, minorities, some of the disadvantaged, or just folks who can't fund that process. So that's why it is very important when we say, it's federal law or Florida law that decides compensation. That's the difference between these people being able to bring and vindicate their right. I don't know if I've gone over my time. Oh, good. So I mentioned the Cackling case, and so the federal government, this is just my perspective on the Justice Department, sort of the career folks at the Department of Justice right now, the themes they're bringing to try to thwart owners, property owners, being compensated. The other one is a temporary versus permanent taking. So the first one I said is they want to recast per se physical takings as regulatory takings so they don't have to pay for it. I mean, that's even a taking that takes, as Robert Thomas said earlier, your right to exclude others from your property, which is one of the most fundamental characteristics of property ownership. But then they also want to say, well, hey, we only took it for a temporary period of time, whether it be 9 months or whether it be 6 years. We can always give you the property back so you don't have a claim, because we can give you the land back at some point. In fact, we may, and if they do give it back, then we don't have to pay anything. So that's the other theme that the Justice Department is raising in the context of these cases. I think it's a theme that's not going to work well for them. I think the Nick case was I don't want to say a watershed, but if you look at several of the recent Supreme Court property cases, I think we've seen a reinvigoration of an appreciation for the Fifth Amendment and for the Takings Clause. So it's no more what Justice Rehnquist earlier characterized as a poor relation. I think the court is more vigorously enforcing that given the current composition of the court, and I think that will continue. And I draw great comfort from Nick, from the Brandt Trust case, which I thought was a wonderful decision of the court by Justice Roberts. He went back to a decision by Justice Rehnquist that he clerked for called Leo Sheep, which is also a very good decision. So I think you see in at least Chief Justice Roberts, Thomas, Alito, and Kavanaugh, as well as Gorsuch, a greater respect for property rights on the court than we've seen in the past. A little less of Justice Kennedy is a wonderful person, and sometimes he was more nebulous about his expression of property interests. And I think the current court, I look forward to decisions that will be more in keeping with what, at least I understand, the Fifth Amendment was intended to accomplish, and that is to protect civil liberties, civil rights of individuals against government intrusion, because the government always has a tremendous advantage whenever they come in against an individual, whether it be state or federal, particularly federal. I find you need that accountability, and that accountability comes from the judiciary. And so a judiciary with a healthy respect for the importance of this, not just about money for people, but it's about individual rights, and that's what we fight for.
So Shelley, go ahead.
I'm going to stand up. I hope you all can hear me. If you have any problem, just raise your hand, and I'll pick up the microphone. First off, you're setting me up. Thank you. First off, I want to thank Linda for having me here, and Andrew and Joe for all of their work that they do in bringing us together. I also have to thank David Callies, who originally introduced me to Steve Eagle, and we've been friends for a long time. And I tell people when I come to this conference, these are my people at the conference. So I'm going to talk for just a couple of minutes about an article that I am going to publish in Kansas Law Review. So if anybody has comments, it's just at the beginning of the cycle. And I've titled that Paying for Disasters. If we look at the floodings that we've had and the wildfires. This is a picture in Malibu, so it came very close, about 5 feet away from much of the Pepperdine campus. And the question is, who is going to pay for all of the property damages from the floodings, from the fire? And so I've been looking at, well, if you go back to the Thomas Fire in Santa Barbara, in 2017, there was then a mudslide that followed and killed several people. And so the individuals sue Southern California Edison. Southern California Edison turns around and sues the city of Santa Barbara for not cleaning out the drains. So we've got tons of litigation going on, which is just very circular because everybody's trying to get someone else to pay the damages. And I don't think that is the efficient way to do things. PG&E has been driven into bankruptcy. San Diego Gas and Electric paid money for inverse condemnation damages, but then when they went to the PUC to get an increase in rates for the ratepayers, they were denied because the PUC said you were being negligent. You weren't really following things, so going to more of a fault basis. We've also had cases with damages from Katrina, the St. Bernard Parish case, and then we've got the Hurricane Harvey damages. And so what I've tried to look at is the difference between using tort law, which is generally protected by sovereign immunity against the government actors, although there are ways to get around that. And in St. Bernard Parish, cert was denied in this situation because the lower court said this was the lack of action on the part of the government to prevent the flooding, and that sounds in tort. So it isn't a taking claim. Lack of action does not get you a takings claim. You need an affirmative government act. So then I started looking at the damagings clauses. Many of you may have heard of this or not. Molly Brady, who was at Virginia and is now at Harvard, wrote an article talking about the damagings clauses, which are in state constitutions in about 27 states. And it combines inverse condemnation with damagings to say that if a government action damages a property owner, they have a right to seek compensation for that. And it's really based on the 5th Amendment and the 14th Amendment. And it came up when the railroads were cutting their paths and they would leave certain properties without access. But because those properties were not being physically taken through the railroads, they were not compensated for that lack of access. The state courts are all over the place on this, but for California, California has recognized inverse condemnation claims, particularly for wildfire damages, without fault. It's called strict liability, but we're talking about a takings claim, not a tort claim. So these are some of the problems. A lot of the state courts, in looking at these damaging claims, have used tort concepts. There needs to be fault, or it needs to be nuisance, there needs to be an intent here, so you see a lot of mixing of tort and inverse condemnation claims. So this is just briefly about the damaging claims. Those are to address those areas where the government has not actually taken or regulated a property, but it has burdened other property owners. how this comes into play with California is that there is a difference between what California does with flooding versus fire. So in the flooding areas, in the flooding cases, California has required a reasonableness standard, which really sounds like nuisance, sounds like tort. But in the wildfire, straight, inverse condemnation, no fault required. Okay, so in one of the flooding cases, though, you see the basis for a takings clause to make sure that, and this goes back to Armstrong case that Steve talked about this morning, that we want to make sure that a property owner isn't burdened. They should be compensated if this is for the benefit of the public as a whole. And that's what's been used in inverse condemnation for the private utilities in California, because they were delegated the eminent domain power, which means then if their lines, their electrical lines supply power for the benefit of the public, if those power lines then cause a fire, then inverse condemnation should take care of those individuals who are burdened by the private utilities giving the public benefit. The federal courts have taken a different view. We have a case in the Federal Circuit where we had the Cedar wildfire in San Diego, and the court said, well, the destruction of property by the forest fire did not benefit the government. But supplying the electricity and setting back fires, that does benefit the government in its management of land. So we've got the federal courts also differentiating between fire and flood, saying that suppressing fires did not set the fire in motion as did the dams set the floods in motion. So trying to distinguish those two type of cases. And then this is something that I think is developing and I think we should be looking at. And that started off with the Federal Circuit in Trinco 2 said that the wildfire backburning that caused damage when it got out of control did not require inverse condemnation payment because the doctrine of necessity. So we have a tort doctrine coming in as a defense against a takings claim. Now, if you look at it, they cite to the Lucas case and Miller versus Schoen, but it's as though we've got this new doctrine, this new defense to a takings claim. So we go back to the federal claims court and they said, yes, we've got this doctrine of necessity, and just recently, last month, well, in the end of August, Orr versus US, that was a flooding claim, and they said doctrine of necessity precludes compensation. So that's where I will leave you on that. Just, we need to figure out who's going to pay for this. I think spreading the costs is what inverse condemnation does. It spreads the cost of what is benefiting the public so that we don't burden individuals. And so I think it should be separated from tort liability and from tort defenses.
Thank you, Shelley. We've got time for a few questions. If we have any questions, Tom Merrill.
This is for Judge Norton, but maybe for Thor too. Nationwide statistics indicate that of all civil trials in this country, less than 1% are now resolved on the merits. They're either settled, dismissed, resolved in summary judgment, or dropped. Is it different in the takings area? Is there a higher percentage of cases that actually get resolved in the merits? And is the ratio of jury to bench trials, obviously not in the federal system, but in the state system, is there a strong preference for jury trials relative to bench trials in the takings, in the eminent domain type cases?
First of all, the statistic of less than 1%, I believe that is just specifically to the United States District Courts. I know in the state of Florida it's higher than that, but that's the amount that's currently quoted, I know, in the United States District Courts. But I think it's basically state by state. I'm a part of the NYU Civil Jury Project program. And in the study of that, I think a lot of how state courts go to trial is the way the state court is managing the docket. Statistics show that more cases are tried by a jury when judges run a pod system, which basically means there's a set of judges that do all the pretrial motions, and then there's a set of judges who actually try the actual case. So with that statistic of how many cases that are civil actually go to trial, I'm just always very specific. It is so hard to say one statistic, 'cause it's so fact-by-fact basis. I think as a trial judge, there is always a preference for it to go to the jury. And that's not just because we want to punt the big decision. I mean, I believe I'm a huge proponent of the right to trial by jury. And I think most of the people, from my perspective, why we want to be trial judges is we defend that right and we hold it so sacred. Do I think my own small section, do I think it's truer in eminent domain proceedings versus other civil proceedings that they're tried more or less on the merits? I don't see a huge difference, but I'm a very small sample. I don't think I would be statistically significant, but it would be something interesting to study. But I know from my own personal experience, I don't see a real difference. So I hope that answers your question.
I think also to add to that, Tom, I think if you took our caseload, probably less than 10% go to full trial. 90% or so would settle. Now, I would still say that's perhaps a decision on the merits, but again, we're not looking to another decision maker. With the mediation efforts in a lot of states as an alternative to resolve the dispute have been very successful. And then also, when cases do go to trial, it helps to set a standard for cases that are still in litigation.
Absolutely.
And so we will, sometimes a case has to break the ice, and then cases will then settle on that principle.
And what,
Cases where you have transportation corridor, you try the first one or two up front, then the rest of the corridor, which may be hundreds and hundreds of cases.
and he's,
It's really dependent upon federal regulations when you're dealing with it. 25, 30 years ago, you had to write a 10-page report on why you settled the case. And the federal government had to approve it or they would defund you from the project. And it was almost easier for lawyers to try the case than to go through a settlement process with the federal government. And it's changed dramatically the way they do it.
Alan Ackerman's bringing out the point from Michigan that,
No, it's the whole country was like that.
well, that condemning authorities had to justify the settlement. And that,
Both parties had to justify it to the federal.
but condemning authorities had to justify settlements. That's still today, and that's a big handicap because they're not willing to take the responsibility, but trials are very expensive and mediation is often best.
well, a good friend of mine who's a tax attorney, he was asking about something I was doing down at the courthouse one day, and he goes, "Oh, are you doing like an administrative order?" I said, "Oh, no, I just make sure everybody's talking about it in the lawyer's lounge." And I said, "That's as effective as an administrative order." That's how it goes to jury verdicts. When the wind gets that there is a certain amount of zeros next to a verdict, that is going to affect, and he's shaking his head yes, whether cases are being settled at mediation or not. And it is amazing, and I know Andrew knows more about this than I do, how quickly that can change whether or not certain parties are settling or not. So.
And some of us, it's like walking the plank, some of us want to try to be the first one to jump off. Because if somebody else sets the precedent, that might not be a good precedent to follow. Another point that you were making, most state jurisdictions under eminent domain have the right of jury trial. Florida does. The only state that I'm aware that the compensation question is decided by a judge is New York. There may be others, but it's federal courts, although we've been advocating the right for jury trial in certain instances, it's typically a discretionary decision by the federal district judge. And for instance, in Florida, with the pipeline cases, our judges affirmed that they wanted jury trials to be deciding the cases. They were open for business, just like they were for tobacco litigation. They wanted to be open for the
And we
small
are.
private owners.
And I would add real quickly, Tom, I think one of the dynamics that I confront when it's the federal government as the adverse party is just the institutional weight of the way the Justice Department works does not favor a efficient or quick resolution. The individual trial attorneys have to get all the approvals, write up a settlement proposal, they actually have to advocate for that internally. It's sometimes easier for them just to blame it on the judge and let the case go to trial. And so that creates this dynamic where it's very hard to resolve the cases, and many of them do either go to trial or on a significant advanced motion practice.
And also as well, before I was a judge, I was actually an attorney for the condemning authority, the city of Jacksonville. And I'll let you know, there is nothing that will encourage a settlement more than knowing the attorney who is representing the private landowner has gone to trial and will go to trial. Because let me tell you, everyone knows, and I'm sure you can echo this, who's not going to go to trial. I mean, there are certain people you just know. I mean, I know as a judge, if I see the name of a certain lawyer, I know one of two things, or one of three things. Either that person's not going to try a case, two, they will try a case, or three, at final pretrial, they're going to bring some hired gun in to try the case for them. And everyone knows it in the trial community, and if you do not think that's going to affect your settlement amount, then you're not doing your homework. So.
Any other questions? Robert Tom? What? Here we go, yeah.
Yeah, I had a question for Professor Saxer, but I think the idea of using takings law to compensate victims of natural disasters is a really interesting idea. But I had a question about how that gets past the problem of the Shelley case, and basically standing for the proposition that the government has no obligation to protect people from private harm. And I assume that applies to natural disasters as well. Is that a case of, trying to get into the state-created danger exception to that doctrine and trying to make, like you said, the difference between the government opening the floodgates or just letting the fire burn? Is that how you get around that problem, or is there something else?
Well, and I would say that that's a problem right now is, I'll put that out of the way. It's a problem, at least with the St. Bernard Parish case, that you cannot get a takings claim for government inaction. And we're seeing this with some of the climate change litigation as well, is trying to say the government isn't doing enough or they need to change their policy. And those claims are hard to deal with. But when you actually have government action, such as backburning or releasing water from the dam to preserve one area and it harms another, that's where I think just using that doctrine of necessity seems to me problematic.
I've got a follow-up on that one, because those anticipated my question is, how does that square the idea that necessity can be a defense to a taking with two things? The idea that the compensation requirement is self-executing. There's been a taking, there's got to be compensation for it. They can't avoid it. And the idea that, what about the public use requirement? Don't you have to concede the validity of government action before you can even think about compensation? You're not trying to stop the taking by claiming it's illegitimate or unnecessary. You're admitting it's necessary and saying at that point you just have to pay me as a cost distribution method. I mean, is that did the court? I thought that Thor case was extremely interesting because we haven't seen the end of that one for sure.
Right.
But I mean, was that raised at all in that case? And that
Well,
makes sense?
not really, but if you look at the Brewer Court, which was in Alaska, picked up on the Trinco case. And what they said is, the doctrine of necessity does not automatically preclude compensation for taking a private property when the government is acting within the scope of its general police power, so you're hitting the public use there. Instead, the doctrine may only be applied to absolve the government of liability when at the moment of the taking there was an imminent danger and actual emergency. So I guess now that's going to be the guideline, whether you get inverse condemnation damages or not. But I see that as a very slippery slope.
Road construction.
Right. So this concerns me that I've seen this doctrine of necessity being picked up as a defense to a taking.
And what Professor Saxer is saying is actually a very important point. Judge Dyke's written some of the decisions, but just to put it into a factual setting, so the St. Bernard Parish case was argued by my friend Chuck Cooper. I wrote an amicus brief. The facts there were the Corps of Engineers built a channel in New Orleans that was such that they unquestioned that this channel caused and sort of channeled all the hurricane flooding into the St. Bernard Parish. So in other words, it wouldn't have flooded but for this government action because of the government building this channel that took the water from Katrina and dumped it into St. Bernard Parish. The government's argued, well, we aren't responsible for that. They argue more of this is a tort, not a taking. And that was some of the analysis that Judge Dyke brought to that decision. I don't think it was the right decision. We sought cert. We did not get cert granted on that. But that's similar to the Hurricane Harvey litigation where the Corps of Engineers affirmatively releases water just like they did near Cairo, Illinois on the Mississippi, where they literally put dynamite on a levee, blew it up so that it would flood farmers' fields instead of flood the other side of the river where somebody's property, where there were some homes. So you're intentionally taking somebody's property by a government act for a public purpose of preserving other people's property. And the theory from Armstrong is in that case, that's fine. Government can do it, but it has to compensate those who bore that burden. And that's where these cases are coming down, I think.
Could I just add one thing? I just want to say thank you to Thor because by inviting me to look at these briefs, this helps me keep informed about the current issues. And so I want to reiterate thanks to you.
You contribute more than I do to that.
So we're going to take a quick break, but we're going to come back for takings, non-governmental takings, which is going to be a very interesting panel. And I thank this panel. Thank you.